Harris Rana, a civil engineering student at Punjab University, on August 5, 2013, after falling from the fourth floor of his paying guest accommodation, resulted in a critical brain trauma described as diffuse axonal injury with complete quadriplegia, which means paralysis in all four limbs, and 100% body disability. Doctors said that he entered a coma, that his nerves in his brain has completely dried up, and has shown no sign of recovering or response to treatment over 13 years. Now, why am I telling you about Harris Rana? Because as of mid-December 2025, the biggest euthanasia-related news from India is that the Supreme Court is actively considering on a plea for passive euthanasia in the case of Harris Rana, a 32 years old man who has been in a permanent vegetative state for about 13 years after a fall in 2013. Now, what is euthanasia, also known as mercy killing? Means intentionally ending a person's life, usually to relieve unbearable suffering from a terminal or incurable illness in a way that is as painless as possible. It is the deliberate act of causing or allowing someone's death with the man's purpose of ending severe pain and suffering when there is no hope of recovery. And it is typically discussed in permanent vegetative state or people with incurable painful conditions. But this act is intentional. The motive is mercy, to relieve suffering, not for any other reasons. Death is brought about in a relatively painless way. There are two types of euthanasia: active euthanasia and passive euthanasia. In active euthanasia, it means directly causing death by giving a lethal injection or overdose of drugs to end the patient's life quickly and painlessly. And passive euthanasia means allowing death by withholding or withdrawing life-sustaining treatment like ventilator, dialysis or feeding tube, so the person dies from their illness rather than from a direct act. Euthanasia also has other classifications. Voluntary euthanasia. Here the patient is mentally competent and clearly asks consent to end their life to escape unbearable suffering. This is what usually means right to die with dignity. Non-voluntary euthanasia. Here the patient directly cannot give consent. Here either he is in a coma or with severe brain damage, and someone else, like a family member, decides on their behalf. This can also be called passive euthanasia, like withdrawing a life support. And involuntary euthanasia. Death is caused against the patient's known wishes or without any consent. In the critical sense, this is generally considered murder, not euthanasia. Then there is euthanasia versus assisted suicide. In euthanasia, another person, usually a doctor, directly causes the death, for example by giving a lethal injection. And in assisted suicide, the doctor provides the prescription for a lethal dose of drugs, but the patient themselves takes the final step to end their life. In many countries, euthanasia is illegal, but assisted suicide may still be permitted under strict conditions. Here are some ethical and legal debates. Euthanasia is one of the most controversial issues in medicine and law because it touches on deep questions about right to die with dignity versus the sanctity of life. Whether doctors should ever intentionally cause death even to relieve suffering. The risk of abuse, especially for vulnerable people like elderly and disabled and poor person. Laws may vary from country to country. In some countries like Netherlands, Belgium, Canada, and parts of Australia, voluntary euthanasia or assisted suicide is legal under strict conditions. And in other countries like India, the UK, and most of the US, euthanasia is illegal, though passive euthanasia may be allowed in certain cases like withdrawing life support with court or family approval. Let's understand the legal framework here. The Supreme Court in Common Cause versus Union of India 2018 recognized passive euthanasia and living wills as part of the right to die with dignity under Article 21 of the Constitution. This was modified in 2023 for easier implementation, with Karnataka issuing guidelines in January 2025 as the first state to formalize it. Active euthanasia, involving deliberate administration of lethal substances, is classified as culpable homicide or murder under Bharatiya Nyaya Sanhita sections 100 and 101. Harris Rana case, December 2025. The Supreme Court has directed AIIMS New Delhi to constitute a secondary medical board to examine Haris Rana's condition and decide whether life-sustaining treatment like feeding tubes and hydration can be withdrawn under passive euthanasia. A primary medical board had already examined him at home and concluded that his chances of recovery are negligible and that he is in a pathetic condition with severe bad sores indicating irreversible deterioration. Justice J.B. Pardiwala and K.B. Viswanathan has said, "We will have to do something now. We can't allow him to live like this." That's for sure, indicating strong sympathy for the family's plea. AIMS were supposed to submit the secondary board's report by 17 December 2025, and the Supreme Court will hear the matter again on 18 December 2025 to decide whether to allow withdrawal of life support. This case has been India's first judicially sanctioned passive euthanasia case where the court formally permits withdrawal of treatment for a patient in a permanent vegetative state, even without a living will. I hope you like this information. Subscribe to the channel for more videos like this, and thank you for watching.